Excellencies, ladies and gentlemen, on the occasion of the International Criminal Justice Day, each year commemorated on the 17th of July, it is my pleasure to welcome you on behalf of Konrad-Adenauer-Stiftung to our panel discussion on the ample challenges the new chief prosecutor at the International Criminal Court faces and the need for reform at the ICC. I'm Andrea Ostheimer, the director of the CAS New York office and representative of CAS to the United Nations here in New York. Since the Rome Statute establishing the ICC came into force in 2002, the court has become an indispensable part of the international justice architecture. Nevertheless, the court faces serious challenges. Major powers such as the US, Russia, China never became party to the Rome Statute. And particularly the Trump administration demonstrated an unprecedented hostile attitude to the court. On June 16th, just a month ago, Karim Assad Ahmad Khan formally took office as the prosecutor of the International Criminal Court, following in the footsteps of Luis Moreno Ocampo and Fatou Bensouda. Khan is taking up his mandate at a time when limited financial and human resources as well as institutional weaknesses contributed to the efficiency issues at the ICC, which in itself spurred further criticisms. Many of those issues have been addressed by an independent expert review of the court, and the detailed report has been presented last fall and certainly can also serve as a good orientation for the new prosecutor. But today we would like to discuss the challenges ahead of Karim Khan with 5 renowned experts on the International Criminal Court. Honorable Lady Justice Joyce Alouach has been a judge at the ICC between 2009 and 2018 and served as its vice president from 2015 to 2018. Ambassador Christian Wennerweser, who hopefully will join us any minute from now, he's the permanent representative of Liechtenstein to the United Nations and has been president of the Assembly of State Parties from 2008 to 2011. Richard Dicker is the director of the International Justice Program of Human Rights Watch since it has been established in 2001. Human Rights Watch is as well a constituent member of the International Coalition for the ICC. Christian de Vos, another panelist, serves as the Managing Advocacy Officer of the Open Society Justice Initiative and just last year published a book with the title Complementarity, Catalysts, Compliance, the ICC in Uganda, Kenya, and the DRC. And with Ottilia Manganidze, we have another international criminal law and international human rights law expert from civil society. Ottilia is the head of special projects at the Institute for Security Studies in Pretoria, South Africa. So with this excellent panel, I don't want to take away much more time. I just would like to invite the audience to post their questions right from the beginning into the chat box so I can weave them also into our discussion. As a moderator, I would like to have this as a real discussion, which also means that our panelists and speakers should feel free to take up points raised by a previous speaker and to comment or to elaborate on that point further. Having said this, and knowing that Ambassador Wennerweser has other obligations and will not be with us for the whole discussion, let's get started right away. So I can't see him still, so I'm not sure what is going on.
And we are adding him right now.
Okay, excellent. Excellent, Ambassador. Nice seeing you again. Thanks for joining us. It's a pleasure to have you in our round. As Liechtenstein has this long-standing commitment to the International Criminal Court and rule of law, and you personally, you served as president of the Assembly of State Parties from 2008 to 2011, and you presided over the ICC Review Conference in Kampala in 2010, which also achieved a consensus on the amendments on the crime of aggression. So being part of the Assembly of State Parties, a kind of oversight body to the ICC, Which are, from your perspective, the main areas for reform which you would identify at the court, and also particularly with regards to the OTP's working methods and structures? And let me perhaps also add a follow-up question immediately. The expert review that I just mentioned has identified a deep level of mistrust between the court and the Assembly of State Parties. Do you perceive this as well? And what are the root causes in your opinion? And how could this also be remedied from an Assembly of State Parties perspective? Thank you.
Thank you, Andrea. Good to see you. And my apologies to everybody. I was in the call, and at least I heard everything that you said. I'm sorry that it seemed that I was not present yet, but I was here from the beginning. So it's a pleasure to be here. Thank you for doing this. Very close to International Justice Day, which was on Saturday. So it's the day that marks the adoption of the Rome Statute. Landmark achievement in the history of international law, and certainly for international criminal justice. I think it's good that you took these two questions together. Because when myself and other previous presidents of the Assembly in a way initiated the process that we're engaged in now, and we asked for an independent expert review, we were frustrated by two elements. One was the lack of support from state parties, and the other was lack of performance from the ICC. And we very much hope that the review process that we find ourselves in, and we always use the term review as is the technically correct expression, but also because we don't think there is a need to suggest that everything is wrong with the ICC. We think that there is a lot is right with the ICC. So we hope that this is the moment where we can bring those two elements back together, and this is what we want to see as an outcome. So, and if we talk about stronger performance on the part of the court, what we have in mind is clearer case selection, clearer priorities, more efficient investigation prosecutions, and of course successful trials. So that all goes together, and frankly also higher quality in the judicial work. It's important that we're talking about the work of the Office of the Prosecutor here. This court will never be successful unless it has an outstanding prosecutor, but the most excellent prosecutor in the world alone cannot guarantee the success of this court either. And I think that is something we have to keep in mind in this discussion. The other parts of the court are essential for that success, but and I really want to emphasize that very strongly as a representative of the state party. We as states have to do our part, and I think we have not done that sufficiently either. So we want to see an outcome in which both aspects benefit. So the performance of the court on the one side, and the commitment from the state parties, and the commitment needs to be manifested in different ways. It needs to be manifested politically, diplomatically, but also financially. And I think that's one of the questions you also want to take up. We are not happy with the de facto zero growth policy that has been in place at the ICC for a good number of years, but we do also not see that will be changed unless state parties are more satisfied with the performance that they see from the court. Most importantly, perhaps, and very much certainly, last but not least, we do believe that it is key for us as states to respect the Rome Statute as it is, and as the treaty that we adopted in '98, in particular with respect to the judicial independence, to the independence of the prosecutor. That does not mean that we all have to agree all the time with everything that the court does. I have certainly, read verdicts of the court where I thought, that was puzzling or disappointing or frustrating. but ultimately we have to respect the judicial independence of the court and try to make this a stronger and a better institution, and an institution that is more aligned, with the vision. We have a very strong vision captured in the Rome Statute, and I think our joint task has to be to take the court as an institution closer to what is reflected in the Rome Statute, and we can only do this together. We can only do this, in a relationship between us as states and the court that is not only not antagonistic, but that is very much mutually supportive. And in order to do that, we have to have a different kind of, basis of communication, basis of dialogue. We need to speak more, not speak less. And talking to people doesn't mean that you're allowing them to tell you what to do, but we have to have a better communication. And when I listened to the prosecutor last week when he spoke to the New York Working Group, he talked a lot about dialogue, and I thought that was a very promising sign, because I do believe that this is what we need. We also need to bring everybody who is in the ICC family back to the table, because the recent years have been dominated by a good number of state parties, but not in a manner that reflects, quite honestly, the membership of the ICC. So, for example, our colleagues from Africa that make up the largest part of the court have not been as present in the discussions as they were in earlier years, certainly as they were in Rome. And to our mind, that is something that needs to change, and we very much look forward to having a very strong and active engagement in this discussion, but in everything that relates to the ICC with all our 122 fellow state parties.
Excellent. Thank you very much, Ambassador, for this elaboration on a lot of points that will meander in our discussion, certainly, but also for highlighting the responsibility of state parties. And I think when it comes to the independence of the court and also the role African states have to play, I would like to move to Ottilia now. Ottilia, when Fatou Bensouda took office in 2012, the ICC faced the reputation and the criticism that it mainly came after African heads of state, as her predecessor had not only issued a warrant of arrest against the then incumbent president of Sudan, al-Bashir, but had also brought forward charges against Kenyan politician and current deputy president William Ruto and Kenyan president Uhuru Kenyatta in relation to the election violence and gross human rights violations in Kenya in 2007, 2008. From your point of view, has Chief Prosecutor Bensouda succeeded in changing this image of the ICC, of being biased towards Africa? And how can now the new prosecutor, Karim Khan, underline the independence, but also the global scope of the OTP's work?
Thank you very much, Andrea. Perhaps to start at a point that Ambassador Venevesa alluded to, which is the participation, or the active participation, let me put it that way, of African member states in processes of the International Criminal Court, and particularly at the Assembly of States Parties. I'm choosing to start there because it responds to your question. The time when a lot of the African member states were quite vocal around the targeting of Africa, or of African heads of state in particular, was starting from late 2008, when at the time it was simply rumors of the possibility that an arrest warrant would be issued for the then president of Sudan, Omar al-Bashir. And it sort of picked up a lot of speed from about early 2009 when the first arrest warrant was issued, and throughout until the arrest warrants, and even after the arrest warrants for not only the now Kenyan president and deputy president, but also people indicted for the situation in Libya as well as in Cote d'Ivoire, among them either current then heads of state or people wielding a lot of political power. It's important to start there because the noise, let me put it that way, had more to do with the particular people that had been indicted and far less so around the broader context in which those indictments were done. And so it was about questions of uneven justice. So when Fatou Bensouda, an African herself, having served as a Minister of Justice for the Gambia before, came into office, the questions around, will there be more African cases, first and foremost, but what about the cases outside of the African continent were quite loud, and rightly so, because while we observe crimes against humanity, war crimes, genocide being committed in other parts of the world, the court role did not reflect that. Now, after Fatou Bensouda has left office, we find situations related to Afghanistan, the occupied territories of Palestine, discussions on Georgia, in particular, the situation in Ossetia. But more importantly, also having broader discussions around the role of other parties outside of the International Criminal Court. When there were efforts to refer the situation in Syria to the International Criminal Court, and the decision was effectively vetoed, meaning, and this is at the UN Security Council, because Syria is not a state party, meaning that the ICC could not proceed. The then prosecutor, Fatou Bensouda, was quite emphatic in what kind of a miscarriage of justice it was that the situation in Syria could not be dealt with simply because Syria is not a state party and because permanent members of the UN Security Council, with some support from non-permanent members, made a decision not to refer Syria. And it was then perhaps for a lot of people that reflections on what it means for an independent international criminal court wanting to do its work, led through the work of the prosecution, can in fact have hurdles thrown in its way, including by the UN Security Council. Today, perhaps if you ask people whether the International Criminal Court is targeting Africa, the answer will be different. And I'll end on this point because one of the reasons the answer will be different is the first head of state to be indicted by the International Criminal Court was Sudanese President Omar al-Bashir. Al-Bashir at the moment is facing prosecution in his home country of Sudan for a range of crimes, including potentially crimes against humanity. The government of Sudan at the end of June committed to cooperating more with the International Criminal Court in the arrest and transfer of suspects to the International Criminal Court. If you had asked me in 2009 whether or not that would ever happen, I would be in doubt. Here is Sudan under new leadership with the former head of state in detention while he is facing his trial in Sudan, potentially going to be handed over to the International Criminal Court. Time, in many ways, Andrea, is a vindicator.
Yeah, excellent. And it underlines also the kind of catalyst function the court can have, and also highlights the aspect of complementarity, certainly. Thanks, Ottilia. I would like to move on now to Honorable Lady Justice Alouroch, who really can provide the insights to the court. You have been a judge at the ICC between 2009 and 2018. You also served as the vice president from 2015 to 2018. And during your time at the court, you have been a presiding judge of pretrial chamber 1 on the situation inter alia in Georgia. And certainly Georgia is one of the examples where more than a decade has passed since the conflict in 2008. And it was initially in August 2008 that then Prosecutor Luis Moreno Ocampo had announced the preliminary examination of the situation. But it had only been in October 2015 that the presidency assigned the investigation of the case to pretrial chamber 1. So certainly these kind of preliminary examinations by the court can catalyze prosecutions at a domestic level. On the other hand, many of the court's preliminary examinations are also dragging on. So there are growing frustrations among victims, and even the collection of evidence might get impaired over time. So how would you assess the situation, particularly also taking into consideration your own experiences in the pre-trial chamber? And where would you see the need for reform, particularly in relation to the OTP's office work?
Thank you, Andrea. First, thank you for inviting me. First, let me make it very clear that I was actually essentially a trial judge. But for the last 3 years, when I was a member of the presidency, and because of the amount of work that was involved, I did step down from the trial division, and I did a few pre-trial chamber work, a few cases. Now, you have mentioned Georgia, particularly, I think you've referred to it. And Georgia itself ratified the Rome Statute in 2003 and subsequently implemented legislation to bring its laws in line with the statute to allow for full cooperation with the ICC. Now, you have given the timelines of what happened when. What I want to say is that as far as the Office of the Prosecution is concerned, as I remember, there are no timelines provided by the Rome Statute for bringing examinations to a close. Examinations, I think, do go on as long as they can manage. Now, and what I can say is that for the Office of the Prosecutor, or rather, the ICC as an institution has no police force. It relies on states parties, or it relies on other countries to assist in investigations. The prosecutor will send his team out on missions, investigators, cooperation advisors, and even prosecutors, and they are going out into the field. So if countries where crimes are allegedly been committed, if they don't cooperate in this respect, then very little work can be done. And I see that as a continuing challenge unless there is cooperation in this aspect. Now, Ambassador Vanavesa has already referred to cooperation by states parties in the sense of funding. That also becomes an issue. I imagine that it becomes an issue as far as investigations, because if I think of the cases that I did in trial, the crimes were alleged to have been committed in large scale. So investigations sometimes it goes across borders, not just one country, it's 2 countries, 3 countries. And the prosecutor is sending teams there. And if they are not given, if the countries do not cooperate, then this will continue to be a problem even to the current prosecutor. It has been to the previous prosecutors and even the current prosecutor. It will still be a problem. And another thing that I see that will challenge the current prosecutor there's a lot of unfinished work. Not a lot. There are a few cases that are problematic, and unfortunately they were not yet concluded. And here you are thinking of a case like the Union of the Comoros, where the authorities of the Union of Comoros, a state party to the Rome Statute, involving that is a situation that is not yet completed. It involves Mavi Marmara to the prosecutor. It was referred in 2013. And this was a ship that was part of the humanitarian bound for Gaza, which was allegedly raided by Israeli Defense Forces in May of 2010. The raid killed 9 victims and severely injured dozens of people. In November of 2014, the Office of the Prosecutor decided against opening a formal investigation into the situation after concluding that the potential cases likely to arise from the investigation into this incident would not be of sufficient gravity. That was 2014. Then the Union of Comoros approached the ICC asking the Office of the Prosecutor to reconsider the decision. In November of November of 2015, the OTP affirmed its earlier decision and declined to open an investigation in the situation. So in November of 2018, the pretrial chamber granted the Union of Comoros further application that an investigation should be opened. And this matter went up to the appeals chamber, and the appeals chamber said that directed the Office of the Prosecutor to reconsider its decision not to open an investigation, and this was in 2019. To date, there is no finalization of this matter. So I know that the Rome Statute say that the Office of the Prosecutor is independent, but that is as far as its work is concerned. It doesn't come directly under the presidency. But when it comes to court orders, when a pretrial chamber has made an order and is subsequently confirmed by the appeals chamber, then I don't think the Office of the Prosecutor has a leeway. So these are some of the challenges that the current prosecutor will face. That's just one of them, and as we go along, I will bring up one or two others as challenges that are still on the table. They are not yet finalized, and he will have to pick them up.
Excellent, and certainly also cases who lead to a lot of frustration, especially when it comes to the victims and their participation. Now I would like to give the floor to Richard Dicker, who really since its beginning accompanies the ICC. And we have heard that there is this review process by the expert panel under the leadership of Justice Richard Goldstone. Human Rights Watch has been also analyzing the findings, and you are also about to formulate your own reflections. But without preempting your analysis, where would you identify the main priorities for reform at the ICC, also from your Human Rights Watch perspective, but also in particularly in relation to the prosecutor's office?
Thank you so much, Andrea. I hope you can hear me. And I want to particularly thank the Konrad-Adenauer-Stiftung for bringing these members of the ICC family together today. Very, very glad to be here. I want to speak to probably 5 or 6 different areas where I believe Prosecutor Khan needs to take action. And all of these come under the rubric of strengthening the court's delivery of justice by improving investigations and prosecutions at the court. First and foremost, very much connected to the independent expert review that has been mentioned, recommendations for changes along the lines I'm about to suggest appear in that very valuable and comprehensive report the experts prepared. First and foremost, I would say we would urge the new prosecutor to pay particular attention to the selection of cases. That is, whom to try and for what. This choice of selection provides the earliest and most visible measure of whether and how the court will bring justice to the victims of the grave crimes in the situations before it. The ability, we believe, of the ICC to have a positive impact in the communities most affected by the crimes the court is looking into will be closely linked to the OTP, the Office of the Prosecutor's selection of cases. And there have been significant gaps in that choice of cases, including the absence of cases against senior leaders in some countries, the absence of targeting a broader range of groups. I'm thinking of Mali, of the Kivus in the Democratic Republic of the Congo. There have also been missteps in decisions as to sequencing cases against different groups. And this mishandling of sequencing, that is deliberately doing one set of cases against individuals from a particular group, has led to a loss of confidence in the court as an independent or impartial institution in some places. Let me go on to call attention to the issue of the pace of investigations, and indeed a challenge the new prosecutor needs to look at. There had been shifts for the better under Prosecutor Bensouda's tenure that would likely require lengthier investigations. But the fact is that long delays in active investigations are limiting the access of victims to justice and reinforcing perception problems as to the court. I'd like to speak on the issue of preliminary examinations that have been mentioned and the related practice of what's known as positive complementarity as a matter of urgent concern for the new prosecutor. The court is a body of last resort. And governments, if they are genuinely committed to trying individuals that the ICC is interested in on the same crimes, may avoid ICC intervention. From our perspective, in some countries, this scenario can give Prosecutor Karim Khan important leverage with the national authorities during this preliminary examination phase, and would serve as a powerful pressure point in his hands to promote progress on the delivery of justice. We do not believe that timelines for the length of preliminary examinations should be codified. We believe preliminary examinations should last only as long as needed to fulfill their purpose, but where the Office of the Prosecutor considers that there are prospects for catalyzing genuine domestic proceedings, subjecting preliminary examinations to strict timelines is, we believe, incompatible with the flexibility this kind of engagement requires. And we would submit to Prosecutor Khan that a better approach is for the office to make increased use of benchmarks by which to evaluate headway on the national level. Let me wrap up with just a few points in passing. The independent expert review reported on incidents of harassment and bullying at the court, particularly within the Office of the Prosecutor. Karim Khan has stated publicly his commitment to ensuring a fair and safe workplace for all staff. We believe his action on this, consistent with the recommendations in the expert report, is crucial. And finally, the issue that has been flagged by several panelists, one of resources. And to give a stark figure, a number of the deep-pocketed ICC state parties have limited the court's budget to more or less zero growth since 2017, despite an expanded workload. And the fact of the matter is, the Office of the Prosecutor remains significantly lacking in budgetary resources needed to support a more effective application of its policies. And the new prosecutor must find the ways to successfully urge member countries to scale up the budget to meet the court's pressing needs and modalities. I'll stop there with thanks again to you.
Okay, thank you so much, Richard. You have addressed a broad range of issues, and we probably would need another 3 hours to go a little bit more into the depth of it. But I think you gave a very good overview. The lack or reluctant cooperation of state parties has been mentioned already a couple of times, but also in recent years we have noted that some non-state parties have turned from a position of lack of cooperation to active opposition, and I would call it even hostile acts. And the most prominent example certainly has been the executive order of the Trump administration to impose sanctions on ICC officials, including the prosecutor Fatou Bensouda. The Open Society Justice Initiative, of which Christian Defoe is the managing advocacy officer, reacted to this and filed a complaint in US courts. Christian, what has been the main motivation for the Justice Initiative to do so? And would you assume that Karim Khan and his team might face similar hostile actions in the future, actions that go way beyond non-cooperation?
Sure. Hi, thanks for that question, Andrea. And just checking if everyone can hear me okay?
Yeah.
Excellent, good. So allow me to add my thanks for the invitation to join this discussion as well. And it's a pleasure to share this virtual stage. Still longing for the day when there might be more than virtual. But I also want to extend my thanks to the Konrad-Adenauer Foundation for its longstanding support of international justice. In terms of quote, active opposition and hostile acts to the ICC, I would certainly agree that the executive order imposed on ICC officials by the Trump administration was the most egregious illustration of this shift you describe. And it's certainly a deeply worrying one, even if for the present moment, the threat of that order has abated. Let me just step back to first address your question about the Justice Initiative's main motivation for filing that legal challenge to the now rescinded order, because there were essentially multiple. I think first, as a human rights law center that's embedded inside the broader global philanthropy of Open Society Foundations, OSJI undertakes human rights litigation and legal advocacy on a range of topics, including international justice. So that includes training local activists to document atrocities, helping local NGOs make communications to the ICC under Article 15, and then working in some cases directly with the OTP on the subject of strengthen the ICC's investigative outreach and communications capacities as sort of an example of some of the work we've done in the past. So like the other 4 plaintiffs in our lawsuit, all of whom were individual law professors, the Justice Initiative provides advice and what would likely have been characterized as a service under the executive order directly to the then prosecutor herself, as well as others in the office. So given that, we really had 4 main concerns. One was the implications of what that meant for our own ongoing and contemplated work with and in support of the ICC. But then relatedly, the ripple effects of this, the threat that it posed to other individuals and organizations working to support the court, and indeed to the court itself to carry out its mandate. I mean, we really saw this as an effort to break the back of the court through crippling financial and potentially criminal sanctions. And so what we saw, and in the end, what a district court judge agreed with was really a gross executive overreach and a misuse of the tool of sanctions to punish judicial officers, human rights lawyers, and activists for their work to advance international justice. And then lastly, I think we cannot, and to the larger question you raised, the reverberations of this order globally and the ways in which it might affect other state support for the ICC and how it might indeed provide a model for how other states who are also interested in undermining the court could pursue similar strategies. And I think more fundamentally, our commitment in all of this was to international justice. I mean, speaking of International Justice Day has just passed, whether that's carried out through the ICC or elsewhere, the ICC is, the infrastructure of international justice, it's an ecosystem. And so a frontal attack on the ICC of this nature, I think, really threatens the entire system, including national justice systems that are meant to be the frontline defenders. So to our relief, the US court system saw things in a similar light and granted a preliminary injunction that barred the order from being enforced against us. And then ultimately, we're pleased that the Biden administration saw things in a similar light. I think a number of us were disappointed, frankly, that the administration did not act even more swiftly to rescind and disavow the order. But fortunately, it did in April of this year. But needless to say, even with these sanctions revoked, I think there's a long way still to go towards building a constructive and cooperative relationship between the US and the ICC. And certainly as a non-state party, US cooperation has been critical to securing the surrender of certain defendants in front of the court. As to the second part of your question, I would yes assume that Prosecutor Khan will face similar hostile actions in the future. And I certainly hope both his office and the court at large, and critically the Assembly of States parties, is harboring no illusions about that. Attilia, I think, made a great point about time as a vindicator, and I think the Sudan example is certainly one where I too would have hardly thought possible the situation we now face. Similarly, however, perhaps naively, I never would have thought that the U.S. government would pursue this kind of action. And so I think that is a chilling reminder that everything is on the table. So I think, and to state the obvious, Prosecutor Khan's obviously inheriting a number of investigations that will continue to displease very powerful political actors, including not only the United States, but certainly Russia and Israel as well. I think the potential for copycat sanctions of that sort is not hard to imagine. And I think, while acting without fear or favor, as she liked to say, for former prosecutor Bensouda, has resulted indeed in the OTP taking brave and legally sound steps to pursue investigations in situations not only beyond Africa, but that raise real these political conflicts. But the court and the ASP, I think, really have to be prepared for these political repercussions, probably better prepared than they have been. And that really requires ICC states parties to have the means and the political will to vigorously defend the institution. And, we have a cooperation working group that exists. I would suggest not in the form of a working group, but some kind of a mechanism amongst states parties that will be prepared to act swiftly and speak in unison when and if we see similar actions is going to be really critical.
Yeah, thank you, Christian. Actually, we have one question from the audience who ties nicely into that. when it comes to the opening of new investigations, which have been very courageous by Fatou Bensouda, particularly also towards the end of her mandate. Our participant would like to know, is there a kind of a past dependency that has been created, and does it also constrain the choices of the new prosecutor on this matter? And would you agree also with this interpretation that he's bound into a lot of investigations now, and how will he address them? Particularly also, and this is a second concern of our participant, to what extent could Prosecutor Khan be considered as biased, particularly when it comes to going after EU actors, as it might be the case in the situation in Libya? Could it be that his geographical origin also predisposes him in a certain way? So I'm not sure who would like to take on these two questions. Ottilia, you're smiling, so please go ahead.
Thanks, Andrea. I don't know if smiling is an indication, but in this case, we are in a conversation on these issues. I'm a fan of history and of timelines. In responding to Jonas Skorsak's question around essentially the current prosecutor inheriting or being gifted, let me put it that way, cases or a poisoned chalice in some instance, I'll start first by way of correction. Efforts to refer first the situation in the occupied territories of Palestine started even before Palestine was given a form of member state status through the UN, when they attempted to refer Operation Cast Lead, which is now marking almost a decade since that happened. Then in 2014, efforts to refer started again. And once Palestine received its status, so to speak, permitting it to, at the very least, sign up to be a member state to the International Criminal Court, things got easier. Why I start there is because it helps in understanding that the Palestine situation is not a Fatou Bensouda situation. It is a situation of continued crimes against humanity that have been committed within the situation where efforts to refer have preceded even Fatou Bensouda's term as prosecutor. That it finally came to be that the chambers, because it's not just up to the prosecutor to make a decision on whether to proceed on a matter, that it finally came to that in this year. To me, as a person who has been keenly watching whether or not that situation would ever get anywhere, to me, it took way too long. That it happened now, quite frankly. A prosecutor, whether it's a prosecutor at the International Criminal Court or a prosecutor at a domestic court, is not tied as an individual to those cases. If a matter must be prosecuted, who is in office is almost inconsequential as to whether or not cases can be made arising from that situation. And I think it's important when we comment on the International Criminal Court or the operations of the International Criminal Court, even those of us that support efforts towards international justice have to be careful not to personalize cases and situations to a point where we think if one prosecutor leaves, then there would not be any success or prospects in respect of a case. Because justice for those situations continues regardless of who's in office. It's also worth stressing that while there is a new chief prosecutor of the International Criminal Court, matters at the International Criminal Court are not prosecuted by one person. It is an office of the International Criminal Court's prosecutor's office, Office of the Prosecutor. Let me abridge it. And that's important to remember, because anything that was collected prior to Chief Prosecutor Khan's coming into office remains part of the office. He does inherit that, but he brings in his own style. What is important, and I'll end with this comment on whether or not Europeans would be brought before the court simply because Khan happens to be from Europe. Again, let's not make it overly personal. However, and this is the part that is interesting where Khan is concerned, because he did serve as legal representative in matters arising, particularly now for Kenya, as a chief prosecutor, he has recused himself in respect of the Gicheru prosecution. Now, if there are lessons on procedure and ways of going about matters, now during Khan's tenure is perhaps the best time for us to learn those lessons. That just because a person has served as defense counsel or even counsel for victims and witnesses at the same court and now holds a new office doesn't mean they can't do their job. So far it's been for Kenya, not even in respect of European prosecutions. The test is ethics. The test is standards and rules by which a prosecutor must be held. And we have to be clear in making sure that that checklist of standards, rules, and procedures is used against all office holders and is used in a way that makes it such that regardless of who's in office, we know what it is that has to be looked out for. Forget the person, focus on the issues.
Okay, excellent, Ottilia. Would anybody from our experts like to add anything? Richard, yes?
Yes, thank you. Very, very briefly. I think if there's one lesson that's clear from 20 years practice of the International Criminal Court, it's this, that if the court is pursuing its mandate in regard to investigating and prosecuting those responsible for the most serious crimes, and if it makes use of its statutory provisions in doing so, it will ignite intense political opposition. We've seen that 3 times in the last 20 years. And that takes me to a point that Ambassador Vennerwasser made that I think is important to underscore. And that is the need for the 123 member states of the Rome Statute to step up in its political defense, a lesson from the rescinding of the executive order imposed by President Donald Trump was that state party opposition to that order and expressions of support for the court, along with the change in US administration, that state party support, whether it was Germany, whether it was Switzerland and Costa Rica, whether it was Belgium, leading other states to say, we support this institution, Washington, D.C. That was a crucial factor and will be needed in the future. Thank you.
Okay, thank you, Richard. I have another question from an attendee who's referring to the situation. Oh, yeah, Lady Justice Aloha, please.
Yeah, I just wanted to restate the point that was made by Otila, and say it this way, that the current prosecutor, has set the trend now. The fact that he just very recently, this month, recused himself from the Kenyan case because he is aware that he's aware of his previous role and he has recused himself, and the pretrial chamber has now confirmed that particular case. So he's taken a very strong leadership role by showing not just people in his office, but internationally, that if you've been involved as a defense counsel and now you change roles, then you must act as he did under Article 42(7) of the Rome Statute. I thought that was a very good example. He started off, yes.
Yeah, thank you very much for also highlighting the kind of provisions for these kind of cases in the Rome Statute. We have another question from an attendee who refers to the cases related to Africa. What could be the key lessons learned by the new prosecutor from the court's engagement in Africa, and what would you see as remaining priorities in the region that he needs to be that need to be addressed by the OTP? Would you like to go first, Ottilia?
Sure, Andrea, and I'll be very brief. I'm mindful of time. I think now, and Richard makes great reference to the fact that we are now 2 decades, essentially, with the operation of the International Criminal Court, or at least the initial steps to. And I think that's an important point of departure, because in that time, the range of cases that have been brought before the International Criminal Court arising from the African continent have actually been quite varied, from post-election violence to ongoing conflict to the destruction of cultural and other forms of heritage, for example. And I think the OTP as an office, but also the incumbent chief prosecutor, can learn quite a lot around the range of international crimes and how best to deal with them. Where there have been challenges, and these have been highlighted already, issues around case selection, sequencing, timing of announcements when it relates to even arrest warrants is important. I've often been the person, and this is my final point on this, who has said, a prosecutor is not a head of communications. And my preference is to see less press statements from the Office of the Prosecutor and more action in court and more convictions. And I think what the African cases have shown us, a lot of them, is the more we focus on public relations, the less we actually focus on the day-to-day nitty-gritty of investigation and prosecution, and perhaps going into the next decade of the International Criminal Court, we hope to see more of, or rather we hope to see less of the prosecutor and more of what is happening at the International Criminal Court and the convictions thereof.
Thank you, Ottilia. Christian was also raising his hand, and I guess Lady Justice Allor would also like to come in on the last part. Thank you.
Sure, I'll be brief as well. I mean, I think the list that Richard went through earlier about the IER and Ottilia's points right now on case selection and sequencing, certainly all very relevant and particularly acute in some of the African situations. I think I would underscore, I mean, a point that has been made, but just a bit deeper, that I think, certainly to date still, notwithstanding the fact that the ICC has opened new investigations in countries outside of Africa, that if we're judging sort of the performance of the Office of the Prosecutor in court, in the investigations and prosecution side, those cases are all still from the African continent and sort of constitute the certainly the early stage of the court's approach under the first prosecutor, and there were changes made under Prosecutor Bensouda. Although in my view, I think we've still yet to see how those changes are. We've seen a little bit, but what is that going to look like in terms of actual new cases brought to trial, and will the overall record of the office improve? What struck me, and I say this as not just my hat of OSJI, but having done doctoral research on the court's intervention in 3 African situation countries, was how distant the court is from the context of those countries. And it did not take me long to sort of really be frankly shocked at the lack of proximity between the situations that populate the court's docket and the way it goes about its work. And that included the composition of investigation teams at the OTP, which did not include an African, to my knowledge, certainly not one from the countries that were under investigation. And I think I overall was really concerned by the sort of Hague-centric approach to not only the overall composition of staff at the ICC, but particularly with respect to investigations. And I don't think it's the only cause, but it is certainly a substantial one for why I think the evidentiary failures that we've seen, at several trials and preliminary hearings, have now come to light through court scrutiny. So I would take, the IER report says many things about this as well, and I certainly would just flag it as a top lesson for a new prosecutor to take on board. As he takes will surely be a thorough review of the office's structure, moving ahead.
Okay, thank you very much. Yep. Christian, you have raised a lot of criticism or points of criticism, and I would like to give Lady Justice Allah also the opportunity to respond and perhaps to reinforce or to also clarify those kind of points. Thanks, Lady Justice.
Thank you, Andrea. At the beginning, the issue was always the prosecutor or prosecutors was always, or the ICC as an institution of targeting African. But then the presidency over the years, whether it was my time or before or subsequently, have always explained outreach that how does ICC gain jurisdiction? And they have always explained state parties have made referrals to the ICC, and most African states made referrals to the ICC. And I remember sitting in one case where the particular country, it was challenged. It was, of course, at that time, there were all cases from Africa. And that the accused person, it was at trial stage, challenged his being, having been brought to the ICC. And that particular state party, it will remain unnamed, sent officials from their Attorney General's office or from the government to come and actually told us, the 3 of us in court, that they did not have, they are not able to handle that particular case. It was for their judiciary, they are not in a position to handle it, and that's why they referred it to the ICC. So as that information has been going out for a long time now through the presidency and even judges as they give talks, that countries, state parties referring cases to the ICC, or the prosecutor using his or her own proprietary powers. And there are just a few cases where that has happened, or the Security Council of the United Nations referring cases to the ICC. In fact, that is what, in my view, from where I sit, that is what watered down the matter that ICC was targeting African countries or African heads of states or Africans. That is what really brought it down. when you start by asking, how does ICC gain jurisdiction? When you answer it, then you'll find that if you examine most of those cases, you'll find that they were referrals by state parties themselves. That's what I wanted to say. Yeah.
Yeah, no, thank you very much. Absolutely correct. I think we have one more request, which I regrettably will not be able to follow, because our participant asked whether we could expand a bit on the independent expert review report, which is a 300-page detailed report, and which would necessitate certainly another Zoom webinar. We will think about it, what we could make out of it, because it has a lot of substance. It's an excellent report, and definitely also something not only the new prosecutor can take up in his work and reorientation of the OTP's office work. I would like to thank our excellent panelists. It was great discussing it with you this afternoon. Your insights are really valuable, particularly as they are complementary from your different experiences and points of view. Thank you very much for sharing your expertise, and thanks a lot to all participants for tuning in and listening to us on this seminar about the ICC, the challenges ahead on the occasion of the International Criminal Justice Day, celebrated on the 17th of July. Thank you very much. I hope to see you soon again. Please stay safe, stay healthy, and enjoy the rest of your day.